Notice of motion. It is declared that the President of the Republic of South Africa has complied with the remedial action of the Public Protector of South Africa, hereinafter referred to as the Public Protector, arising out of the investigation and report into allegations of maladministration and impropriety in the approval of Mr. Ivan Pilay's early retirement with full pension benefits and subsequent retention by the South African Revenue Services, bearing reference number 201920, hereinafter referred to as the report, in that the President has 2.1, in compliance with paragraph 7.1.1 of the report, noted the adverse findings made in the report against the second respondent, that is now the Minister, and 2.2, within 30 days of the issuing of the report and in compliance with paragraph 8.1 of the report, submitted an implementation plan to the Public Protector indicating how the remedial action in paragraph 7.1.1 of the report will be implemented. This is now the implementation plan. 3, the President is directed, in accordance with the implementation plan and subject to the decision of this court in the review application under case number 36099 of 2019, that is the Minister's review application, to take appropriate disciplinary action against the Minister within 30 days from the date of the final determination of the Minister's review application, including the final determination of any subsequent appeals. 4, alternatively to paragraph 2 and 3 above, it is directed that the President's obligation to implement the remedial action of the Public Protector in paragraphs 7.1.1 and 8.1 of the report is stayed pending the final determination of the Minister's review application, including the final determination of any subsequent appeals. 5, that costs of this application shall be paid by any such respondent who opposes the application on an attorney and own client scale, including costs of 2 counsel. The parties. The applicant is the President of the Republic of South Africa, hereinafter referred to as the applicant. The first respondent is the Public Protector of South Africa, hereinafter referred to as the Public Protector. The second respondent is Pravin Jamnadas Gordon, hereinafter referred to as Minister Gordon. The Economic Freedom Front, the EFF, brought an application to intervene in these proceedings. Both the President and the Public Protector are not opposing the EFF's application for intervention. Accordingly, the EFF is joined in these proceedings as the third respondent. Minister Gordon is not opposing the application and he does support the application. Both the Public Protector and the EFF are opposing the application. As already indicated, this matter came on an urgent basis. Urgency is not in issue, as all the parties agreed that it is in the best interest and in the protection of our democracy that this application be dispensed with as quickly as possible. Points in limine. The Public Protector had raised some points in limine, primarily relating to the jurisdiction of this court to deal with this matter on the issue of the declaratory order sought by the President, on the basis that the President has failed to fulfill his constitutional obligation, which arise from Section 83 of the Constitution of the Republic of South Africa, hereinafter referred to as the Constitution, as well as non-joinder of Messrs. Pillay and Kisweta, the erstwhile and current commissioners of SARS, respectively, in these proceedings. It was agreed that I should deal with the points in limine. I should not deal with the points in limine at the beginning of the case, as it is usually done, but that I should rather hear the whole argument on both the points in limine and the merits of the application, and then decide on these at the end of the case. I will deal with the points in limine later. The following is a summary background to the issues leading to this application. On 24 May 2019, the Public Protector published a report bearing reference number 24 of 2019/20, hereinafter referred to as the report, containing findings made and the remedial action to be taken against Minister Gordhan. The remedial action arises out of the Public Protector's report on investigation into allegations of maladministration and impropriety in the approval of Pillay's early retirement with full pension benefits and subsequent retention by SARS. The remedial action includes that the President must take disciplinary action against Minister Gordhan. The remedial action that is relevant to this application states the following. At paragraph 7.1, the President of South Africa, 7.1.2, I'm quoting, to take note of the findings in this report insofar as they related to the erstwhile Minister of Finance, Mr. Gordhan, and to take appropriate disciplinary action against him for failing to uphold the values and principles of public administration entrenched in Section 195 of the Constitution and the duty conferred on members of the Cabinet in terms of Section 92, bracket 3, bracket A of the Constitution to act in accordance with the Constitution. Paragraph 8 of the reports, which deals with monitoring, reads as follows. 8.1. The President of the Republic of South Africa must, within 30 days from the date of the issuing of this report, and for approval of the Public Protector, submit an implementation plan to the Public Protector indicating how the remedial action referred to in paragraph 7.1 of this report will be implemented. On 28 May 2019, Minister Gordhan launched a review application in this court under case number 36099 of 2019, amongst others, for the Public Protector's report number 24 of 2019-20 to be reviewed and set aside, declared unconstitutional, unlawful, irrational, and invalid, including the remedial action in paragraph 7 of the report. The President submitted an implementation plan wherein he sets out his plan of action on the terms set out in a letter dated 19 June 2019, where he states the following, and I read from paragraph 5 of the said letter. Open quotes, my letter is in accordance with my obligation in paragraph 8.1 of your report. 6. In relation to your direction to submit my implementation plan, I reply as follows. 6.1. I have noted the findings against Minister Gordhan in your report. 6.2. I have noted too the assertions made by Minister Gordhan in his review application that your report falls to be reviewed and set aside because it is allegedly ultra vires Section 6(9) of the Public Protector Act, issued by means of an unfair procedure and tainted by misdirections of law and fact. 6.3. One of the legal complaints raised by Minister Gordhan is that the direction that I take appropriate disciplinary action against him is vague and impossible to implement in the absence of an employment relationship between the President and myself. 6.4. Having considered the finding against Minister Gordhan in your report and in his challenges to those findings in his review application, I have concluded that it would be inappropriate to take disciplinary action against Minister Gordhan at a time when 6.4.1. Not only is there a dispute pending before the High Court over the legality of the findings on which to base such disciplinary action, but also my alleged power to exercise such disciplinary action is itself legally contended by Minister Gordhan in that dispute pending before the High Court. At 7, the President states, in the circumstances, my implementation plan in respect of the remedial action set out in paragraph 7.1 of your report is the following. 7.1, I have complied with the order to take note of the findings against Minister Gordhan in your report. 7.2, I have concluded that the process of taking appropriate disciplinary action against Minister Gordhan would best be served by waiting until the legal processes of his review proceedings have clarified. 7.2.1. What disciplinary powers, if any, the Constitution allows me to exercise over Minister Gordhan beyond removing him from Cabinet? 7.2.2, whether there are lawful grounds for the exercise of any such disciplinary powers. 7.3, I intend accordingly to defer my decision on what disciplinary action, if any, to take against Minister Gordhan until final determination of his review application. 8, I trust that you are satisfied with this implementation plan. If you are not satisfied and require me to exercise any disciplinary powers I may have over Minister Gordhan before his review application have been finally determined, I invite you to approach the High Court for an order compelling me to do so. As can be seen from the letter just read above, the President explained the President's reasoning for the implementation plan adopted, especially at paragraphs 6.3 and 6.4 above. The Public Protector replied as follows to the President's letter aforesaid in a letter dated 26 June 2019. And I quote from paragraph 2. It is tried that the remedial actions of the Public Protector are binding unless set aside by a court order, as was stated by Mkhwebane CJ in the matter between Economic Freedom Front versus Speaker of National Assembly, 2016 ZACC. This is an unreported, it was unreported at this stage. While it is established law that a report of the Public Protector can be reviewed and set aside through a judicial application, the institution or intention to institute such proceedings does not automatically pend the implementation or enforcement of the remedial action. 3, as the law currently stands, a review application does not suspend the enforceability of a decision, administrative act, or a judicial edict. This principle was settled by the Supreme Court of Appeal in the matter of the EFF versus DA 2016, Volume 2, SA 522 SCA, where the court reaffirmed the position as laid in Odegral Estates Limited versus City of Cape Town and others, 2004 6 SA 222, an SCA decision, that it is settled in our law that until a decision is set aside by a court in proceedings for judicial review, it exists in fact and has legal consequences that cannot simply be overlooked. It is clear from the above that any advice to the effect that a review application stays the implementation of the remedial action is incorrect and is a sheer display of cluelessness on the person giving such advice. Paragraph 4, to this end, the President's letter is not only based on the wrong understanding of the law, but on a mere assurance by a third party that the President should not comply with my remedial action. 5, the President's refusal to act on my remedial action is a failure on the President's part to uphold the Constitution. Absent of an order directing otherwise, my remedial action are binding and compliance thereto is not optional. Contrary to the President's advice that I should approach the court for compelling compliance, it is the President who must approach the court to interdict my remedial action. This is another indication that the President relies on incorrect advice, legal or otherwise. I can deduce from the President's letter that the decision not to implement was a foregone conclusion, as it is merely based on Gordon's assertions and nothing else. 6, in an attempt to dispel the myth that a mere review application automatically suspends an impugned decision, I copy Mr. Gordon's legal representatives on this correspondence. 7, the public protector will therefore persist with the enforcement of the implementation of the remedial action to the parties directed against until such time that an interim order interdicting same is obtained. On the 3rd of July 2019, the President responded to the letter of this public protector, stating that he fears that the public protector has misunderstood his letter of 19 June 2019 in that he has not refused to act on the public protector's remedial action. He states the relevant paragraphs, I quote, the relevant paragraphs of your report directs me to take note of the findings in this report insofar as they related to the erstwhile Minister of Finance, Mr. Gordon, and to take appropriate disciplinary action against him for failing to uphold the values and principles of public administration entrenched in Section 195 of the Constitution, and the duty conferred on members of the Cabinet in terms of Section 92(3)(a) of the Constitution to act in accordance with the Constitution, and you further directed me to submit within 30 days an implementation plan indicating how I will implement the remedial action. I have complied with your direction by firstly taking note of the findings in your report insofar as they relate to Minister Gordhan, and secondly, sending you an implementation plan indicating how I will implement the remedial action you have directed me to take within 30 days deadline that you directed I do so in paragraph 8.1 of your report. You appear to have concluded that I am refusing to act on your direction to take appropriate disciplinary action against Minister Gordhan. This is not the case. In terms of your direction, it is for me to determine what is appropriate disciplinary action to take. As pointed out in paragraph 5.4 of my letter of 19 June 2019, I have concluded that at this stage, for the reasons stated in my letter, there is yet no action that would be appropriate to take. I am advised that this is a legally sound conclusion to reach on the basis of the judgment of the Supreme Court of Appeal in Samwerk Southwerke Pty Limited versus Minister of Resources and another 2019 ZASC A56, heard on the 19th of May 2017. In this case, the Department of Mineral Resources decided not to take steps to finalize a mining right while two private parties litigated over the validity of that right in proceedings to which the department was a non-disputing party. At paragraph 66 of the judgment, the Supreme Court of Appeal stated the following: the policy of the department was not to finalize a mining right whilst litigation was pending regarding the validity of that right. It was, in my view, perfectly in keeping with public legal policy not to undermine the legal process by determining that which the courts were called upon to decide. The President continues in his letter and states, I believe that applying the principle of the SCA judgment to the present situation, it is perfectly in keeping with public and legal policy for me not to undermine the legal process by determining that which the High Court has been called upon to decide in the dispute between Minister Gordhan and yourself. He continues by stating, as proceedings in the review application unfold, the state of affairs in relation to appropriate action may well change. Should this happen, I will promptly notify you of any resultant changes to my implementation plan. In a further letter dated 9 July 2019, the Public Protector responses to the letter of the President aforesaid and states, amongst others, the following, and I quote paragraph 9, I fear that the Honorable President's persistence on willful non-compliance with my remedial action, which is based on the Honorable President's incorrect interpretation of the law, is not only ostensibly contemptuous of my office, but also borders on a breach of the Honorable President's constitutional duties as spelled out in the Constitution. At 12, she says, I therefore plead with the Honorable President to avert the constitutional crisis alluded to above by taking heed of my advice and implementing the remedial action as set out in the report or obtaining a court interdict to stay the implementation pending the outcome of the review proceedings, or even causing the implicated and/or affected public officials to do so. Such orders are sought and obtained in our courts in respect of review applications targeted at ordinary administrative action, let alone the remedial action of the public protector, which almost ranks as a court order in its binding effect. From the reading of the correspondence aforesaid between the President and the Public Protector, the issue between the parties can be defined as follows: whether the President has complied with the Public Protector's remedial action contained in the Public Protector's report of 24 May 2019. This is what the declarator seeks to achieve, that is prayers 1, 2, and 3 of the notice of motion. The President's case is that he has acted in compliance with the remedial action. Alternatively, that the President's obligation to implement the remedial action of the Public Protector be stayed pending the final determination of the Minister's review application. This is in case he fails, the President fails in obtaining a declarator from this court. Minister Gordon is not opposing, and he supports the application. Both the Public Protector and the EFF are opposing the application. Minister Gordon supports the application on the basis that there is no compelling reason to immediately implement the remedial action imposed by the Public Protector in the report. The Public Protector and the EFF are opposing the application and contend that the President has not complied with the Public Protector's remedial action and has not made out a case for the stay of the implementation of the remedial action. The Public Protector further contends that the President refuses to implement the remedial action of the Public Protector, and that undermines the office of the Public Protector. Further, that the President seeks an order against himself to suspend the powers of the President to act expeditiously against members of the National Executive against whom there are adverse findings. She contends that in granting the order sought by the President, the constitutional work of the Public Protector would be undermined. The EFF contends that the President has not complied with the remedial action of the Public Protector, as he has up to now not taken any disciplinary action against Minister Gordon. And I deal fully with these contentions. As correctly contended and submitted on behalf of Minister Gordon, the Public Protector accepts that the fact that there is a review application does not stay the implementation of the remedial action in the absence of a court order. This is in view of the public protector contending that the President has launched this application to seek legal advice from the court. The contention further states that this application is not seeking legal advice from the court. The application is seeking the relief, a declaratory and mandatory or stay as is routinely granted in such matters pending the final determination of the review. The President is seeking the court's assistance because of the opposition he encountered from the public protector to his implementation plan. This is the only avenue to the President in the face of the public protector's ultimatum to him to do precisely what the President is doing now, seeking a temporary suspension of the implementation of the remedial action pending the outcome of the review launched by Minister Gordon, which challenges the report and its remedial action. It's important to state that, in essence, the President contends that he has complied with the remedial action. However, he seeks the suspension of the implementation of the disciplinary action against Minister Gordon. It is clear that the parties are at odds as to what is required of the President, flowing from the Public Protector's report. And thus, the President has approached this court to provide clarity on these issues. There is no cogent reason to implement the remedial action immediately prior to the final determination of pending review by Minister Gordon of the report and the remedial action. This is so particularly given the vague, so contents. This is now what the Minister Gordon contends, that given the vague and confusing formulation of the remedial action itself. As stated above, the remedial action in the report required that the President take note of the findings in this report insofar as they relate to Minister Gordon. It is not contentious that the President has indeed taken note of the report, of the findings of the report. The Public Protector self accepts that the President has taken note of the findings of her report insofar as they relate to Minister Gordon. The report, the remedial action set out in the report is silent as to when the President is required to take appropriate disciplinary action. The President contends, and it was so submitted on his behalf, that the Public Protector has left the issue pertaining to the time when to implement the disciplinary action and the how to the discretion of the President. I may state that there is correspondence where the public protector at some stage gave the President an ultimatum to comply with the remedial action, more specifically to take disciplinary action against Minister Gordon by the 12th of August 2019. That is, in essence, a variation of the report, since in the report there is no time stipulation within which the President must act. Of course, it is incumbent on the President to act within a reasonable time. However, the President, having adopted a sensible approach, states that he will await the finalization of the review application launched by Minister Gordon. The public protector, the EFF contends that since the President has not taken the review, the public protector's report on review, clearly he has accepted the factual findings of the report, and that therefore he must take disciplinary action immediately. I may state that the President, at no stage or in his affidavits, both the founding affidavit and the replying affidavit, does he attack the factual basis of the report, nor does he deny that the remedial action is binding on him, and also acknowledges that a review does not necessarily suspend the implementation of a remedial action unless a party approaches a court to have such remedial action suspended. It has been done many times with the consent as well of the public protector. For example, there's a matter which came before this court on Tuesday, 30th July 2019, wherein the applicant Phumelela launched a review application and brought an application on an urgent basis to have the remedial action of the public protector stayed pending finalization of the review application. The public protector did not oppose that application and in fact consented to the order staying the implementation of the remedial action pending the final determination of Phumelela's review application to have the report of the public protector reviewed and set aside. Also, in a matter on the 1st of August 2019, the public protector consent to a suspension. Basically, staying and suspension has the same effect. The suspension of the remedial action in a matter involving the president. Both the president and Minister Gordon question why, in this case, the public protector is not being consistent in agreeing to the suspension of the implementation of the remedial action. I may state that there are two cases in this division. The matter which was heard on 23 July 2019 before my sister Potero, where the effect of the order granted interdicting the implementation of the remedial action temporarily, the legal principle in that case basically has the same effect, is the same as this one, because they have, both cases have the same effect, that is now having the implementation of the remedial action suspended. In the president's case, more specifically, pertaining to the disciplinary action which the president is implored to take against Minister Gordon. Another case from this division, though Gauteng South by my brother Makume, where the effect is the same, where the erstwhile President Zuma had launched an application, a review application, to suspend the operation of the remedial action pending finalization of the review application that he had launched. And in that case, the erstwhile President Zuma was successful. The order was granted, suspending the operation of the remedial action by this, issued by the public protector. These basically relate to consistency. The president and Minister Gordon are correct in stating that there is no consistency, and further that there are two cases which I've already mentioned, the one by my sister Potero, the other by my brother Makume, which has the same effect, and it is mind-boggling basically why in this matter the public protector did not even consent to, at least if she doesn't want to consent to the declaratory order, to have the remedial action stayed pending finalization of the review application launched by Minister Gordon. The public protector contends that there is a close relationship between the President and Minister Gordon, i.e. that they are friends, and that the President basically is protecting Minister Gordon. The President disputes this. In fact, he even did not want to give that assertion any dignity. And he correctly states this has to do with legal issues. It has nothing to do with friendship between the President and Minister Gordon. I am not even going to consider that aspect. I am of a view that that merely clouds the issues. The issue here is whether the President has complied with the remedial action. If he has not, he is seeking an alternative relief to have the remedial action, the implementation of the remedial action, more specifically, the implementation of the disciplinary action against Minister Gordon, stayed until finalization of Minister Gordon's review. Looking at the facts, Minister Gordon, I retract, looking at the facts and the correspondence between the parties, and on a proper reading of the letter by the President to the Public Protector, the first letter, the letter of 19 June 2019, the Minister has complied with the remedial action. The Public Protector herself states that she required the minister the President to take three actions. Three actions. One, to note the findings against the minister. Two, to take appropriate action against the minister. Three, to provide the President, to provide the Public Protector with an implementation for the Public Protector's approval. Clearly, the Public Protector does not approve of the implementation plan which the President submitted to her. What does one do if the Public Protector does not approve of one's implementation plan? One would do what the President has done. One would approach the court. The Public Protector herself has indicated in the letters that I have read, in the correspondence that I have read into the record, it appears many times from what the Public Protector says to the President that the review does not suspend the operation of the remedial action unless a party approaches the court for a stay or suspension of such remedial action. I've already stated the public protector has consented in this week only. She has consented to about 2. No, it's not, it's last week, no? The 30th, on the 30th and the 1st of August, she consented to 2 suspensions of remedial actions. Counsel for the respondent, and in fact the president as well of the second respondent, the minister, and the president as well, suggest that the public protector is taking this matter personally. And when one sees the language she uses in her address to the president, that is now in the correspondence that she has sent to the president, to tell the president that the people who are advising you, basically she's saying that they do not know the law, they are incompetent. And she explains, she complains basically in her affidavit, and submissions were made in that regard, that Minister Gordon is insulting her in his founding affidavit in the review application. And she even goes further to state that the president, by not taking disciplinary action and by stating that he does not regard the Minister Gordon's application as frivolous, in fact is endorsing the insults that Minister Gordon is hurling at her in his affidavits. The president has set the record straight, and in his replying affidavit, he states categorically that he does not in any way associate himself with whatever the public protector calls insults to the president. And if one looks at the report, the report itself, and as considered properly so by the public protector, it is silent on when and how the disciplinary action should be taken. The president has complied. The president was left, in terms of the timing and the form of the disciplinary action, the president was left with the discretion, and he has duly exercised his discretion, and he has taken a sensible approach to say that he will defer. He is not saying he will not take remedial action or he will not take disciplinary action against Minister Gordon. He is saying he will defer the implementation of the disciplinary action pending finalization of Minister Gordon's review application. It is incumbent on the President to act reasonably and rationally. And in my view, this is a reasonable and rational decision which he has taken. It was argued both on behalf of the Public Protector and the EFF that the President in this case is not the victim and that he was not supposed to have brought this application to stay the implementation of the remedial action, that it should have been Minister Gordon who should have asked for the relief sought, more specifically pertaining to prayer 4, the alternative relief. That argument loses sight of the fact that the President is the one who is obligated to take remedial action. It's not like any man in the street who would just come and say, I want to bring this application on behalf of somebody. The President is the one who is enjoined to take the remedial action. And he has a right to approach this court. In the correspondence from which I have read, the Public Protector herself states that either the affected or the President may approach a court for a suspension or stay of remedial action pending finalization of the review application that one would have launched. And as I stated, it is mind-boggling that she is now not consenting, or she has not consented to the stay of the remedial action pending finalization of Mr. Gordon's application. It was suggested by both the Public Protectors Council, even in the answering affidavits, that the President can take remedial action by way, for example, of reprimanding Minister Gordon, or by way of suspending him, or by way of stating that he should forfeit maybe a month's salary. That impacts on Minister Gordon, and that would be irreversible in the event Minister Gordon were to be successful in his review application. I am deliberately not going to express my prima facie view on the review application. I leave it to the court. I do not want to intrude into the court that will be dealing with that review application. However, Minister Gordon, like everyone else, has rights, and that is entrenched in the Constitution. why subject him now to disciplinary action when there is a review application pending, the result of which is not known? It is important, and I will reiterate, that the President is not saying that he is refusing to implement the remedial action. The President accepts that the remedial action is binding, further that the review does not suspend it unless he approaches the court as he has done. And he is not challenging, in the affidavit, he is not in any way challenging the factual findings of the public protector in the report. All he is saying is, let me await the final determination of the review, and to me that is rational and reasonable, and as the President of all in the country, not a friend, as the President of all in the country, including Minister Gordon, he has to, as obliged by the Constitution, act rationally and reasonably. It will be clear from what I have said that Minister Gordon, the President has made out a case for the declarator sought, and once the declarator is granted, prayers 2 and 3 will follow. However, I want to state that in the event he had not even succeeded on the declarator, it would have been in the interest of justice still to grant the alternative relief, but my judgment is going to be based mainly on the issue, my order will be based mainly on the issue of the declarator. And the fact, as contended by counsel for the public protector, that the public protector has not approved the implementation plan, does not in any way, and that as a result thereof it cannot be said that there has been compliance with the remedial action. Obviously, and I think it makes sense that it is not in all cases that the public protector would approve. So the fact that she has not approved does not mean that there has not been compliance. And I have already stated on a conspectus of all the facts, looking at the conduct, the engagement of the President, and at, more specifically, at the letter dated 19 June 2019, the President read with the remedial action imposed on him. The President has complied. There is no time frame set out by the public protector, nor the form of implementation. And on the issue then of a declarator, I am satisfied that the President has made out a case for the relief sought. And now to deal with the issue of the points in limine. The public protector contends that the president, the matter before this court falls within the exclusive jurisdiction of the Constitutional Court. In that, so contends the public protector, the president has not complied with his constitutional obligation in terms of Section 83 of the Constitution. And to this, the president correctly states that this is just a simple issue where the president and the public protector and the EFF, now as they have intervened and joined as third respondents, do not see things in the same way, and hence coming to the court for a declarator. It has nothing to do with the president not having fulfilled or acted in where the president has not acted in a way where he breaches his obligation in terms of the Constitution. Insofar as the issue of the point in limine is concerned, the second one, the non-joinder issue, the public protector contends that the president has not joined Mr. Pillay and Mr. Kisweta, the erstwhile commissioner and current commissioners of SARS. This matter purely has an impact on the Minister Gordhan. It has nothing to do with the commissioners, the erstwhile commissioner and the current commissioner. Counsel for the public protector correctly considered that it is the Minister Gordhan, is the only one that has an interest in this matter. On the papers, there is no way that Mr. Pillay and Mr. Kisweta would have any interest in the outcome of this application. The points in limine, therefore, cannot hold. Insofar as the issue of costs is concerned, it was argued on behalf of the public protector as well as the EFF that the president is intimidating the public protector by stating that he would ask for costs on a punitive scale, special cost order. In a letter from the state attorney, which was handed up in court, the state attorney, who are the attorneys for the president, state, this is after my sister Potero had given judgment in the matter between Minister Gordon and the public protector, favorably so for Minister Gordon, the effect of such order, which is in principle, the effect of which would be this, what would be sought in this matter. The state attorney then sent a letter to the public protector imploring her to consent to the order sought in the notice of motion in this matter. Further, that if she doesn't consent, they would advise their client to seek punitive costs. They would advise, I reiterate, their client, the president, to seek an order for costs. On a proper reading of that letter, it is clear when they wrote that letter, the president had not at that stage given them instructions to threaten or intimidate the public protector with a punitive cost order. They specifically state they will advise, which basically means that at that stage they did not have the instruction from the president. So it cannot be said, because Mr. Mpofu for the public protector said in this court that I should pronounce on that issue of cost, and that is specifically why I'm mentioning this. It cannot be said from the reading of that letter that the president was trying to intimidate was intimidating the public protector, because the letter is clear. At the time the attorneys wrote that letter, they would seek the advice. They would advise their client to seek a special cost order. It is important to note that counsel for the president did not pursue. I know in the notice of motion, the relief sought in prayer 5 is that any party that would be opposing this application would be required to pay costs on an attorney and own client. This is what is stated in the notice of motion. However, counsel for the president did not pursue that during argument, and he correctly left the issue of costs to the court. It is tried that the issue of cost is within the discretion of the court. And he specifically stated that he was leaving that issue of costs to the court. I just need a comfort break. We'll come back after 5 minutes. Just 5 minutes. Court agents. Vicky. economic freedom fighters. My apologies for that. I was on the issue of costs. And as I stated, costs are within the discretion of the court. Counsel for the President did not persist with an order for costs on an attorney and client scale. He left the issue of costs to the court. It is tried that the question of costs is a discretion of the court, which must be exercised judicially. The award of costs is to be decided on the basis of fairness and equity. It is a general rule that costs follow the result. The successful party is entitled to costs unless there are good reasons to depart from such rule. There is no reason why same cannot apply here. Both the public protector and the EFF's counsel submitted that in the event the President were to be successful, the BioWatch principle must apply. I have already stated, insofar as the public protector is concerned, that it is not understandable really why she was opposing a stay of the remedial action pending the finalization of Minister Gordon's review application. The EFF as well was basically being unreasonable to want to demand that the President must take disciplinary action immediately without having regard to the pending review application. And I do not see that the justice would be served if the successful parties were not to be granted an order for costs. And I've already indicated that I am satisfied on the papers, having considered the submissions made on behalf of all the parties before this court, that the President has made out a case for the order sought in prayer 1, and the prayers 2 and 3 basically have to follow. The President has complied with the remedial action, and as indicated, he has acknowledged and accepted, and he accepts, correctly so, that the remedial action is binding on him. And this is not a case which can be compared to the EFF case, where the EFF sued the Speaker of the National Assembly. That is now the Nkandla matter involving President Zuma, who wanted to run parallel process in Parliament instead of implementing the remedial action. In fact, he did not see himself bound by the remedial action until the court in that matter held that the remedial action is binding. So the case, the Nkandla case, cannot in any way be compared to this matter, where the President correctly accepts that he is bound by the remedial action and he's not refusing to implement it. He is just deferring it and acting, that is now acting rationally and reasonably, as I've already indicated, pending the finalization of the review application by Mr. Kodang. And having said that, and on consideration of all the facts, I come to the conclusion that the President has made out a case for the relief sought, and the following order is made. I will first deal with the issue. I've already indicated that there is no substance in the points in limine. The points in prayer one, the following relief is granted. For the following order is granted. 1, the points in limine are dismissed. 2, it is declared that the President of the Republic of South Africa has complied with the remedial action of the Public Protector of South Africa arising out of the investigation and report into allegations of maladministration and impropriety in the approval of Mr. Ivan Pilay's early retirement with full pension benefits and subsequent retention by the South African Revenue Services, bearing reference number 24 of 2019/20, in that the President, 2.1, in compliance with paragraph 7.1 of the report, noted the adverse findings made in the report against the second respondent. This is now the Minister. And 2.2, within 30 days of the issuing of the report, and in compliance with paragraph 8.1 of the report, submitted an implementation plan to the Public Protector indicating how the remedial action in paragraph 7.1.1 of the report will be implemented. This is now the implementation plan. 3, the President is directed in accordance with the implementation plan and subject to the decision of this court in the review application under case number 36099 of 2019, that is the Minister's review application, to take appropriate disciplinary action against the Minister within 30 days from the date of the final determination of the Minister's review application. 4, the Public Protector, the first respondent, and the third respondent are ordered to pay the costs of this application the one paying the other jointly and severally, the one paying the other to be absolved. Such costs to include the costs consequent upon the employment of 2 counsel. The court adjourns.